said to have been filed by one Issa Mansour. That application is pending. We take the view, two reasons if we need to make the argument. First of all, we have a notice of appointment of advocates that predates the entry of Issa Mansour. Best civil practice would have required, if a legitimate change of advocates was to be made, for a notice of change of advocates to be filed. No such action was filed by what I consider a very, very competent firm of advocates. So there, in our view, there must have been collateral purpose. Secondly, it is not the work of the commissioners of IEBC, whether in majority or in minority, to procure any services. That flies totally in the face of the procurement law in this country. As we sit here now, the four who purport to have procured have committed a criminal offense and should be treated as such. So in my opinion, what I understood my lady and the court to have said earlier in your ruling was that IEBC was properly represented by its advocates on this table. However, the four individual commissioners who are now cited as respondents, but who are supporting the petition, will continue to enjoy the very distinguished services of my senior learned friend, the Honorable Paul Mwita.
Your Ladyship, Madam CJ, there's something that is likely to be lost as my two learned friends are fighting. And it is so important, it could compromise really the fairness of the hearing which you have endeavored with so much effort to craft a way forward. It is this: 8 petitions were filed against my client within the 7 days cast in stone in the Constitution. It is the first time in this republic that 8 are filed. In 2013, there were 2. But because of ingenuity of this side of the court, we now can file very many, all intended for the same purpose. That aside, I burnt midnight oil, filed my response within time. Then comes the group of 4 commissioners. On 26th August, they have filed a response to the petition. They are filing this under the pretext they are respondents. They file a response. It is not a response. It is a new petition. There are new claims, new grievances, new grounds for nullification of my client's electoral victory.
Senior counsel.
Yes.
I think a ruling was delivered on their participation as respondents.
If you could just allow me 1 minute.
What we are addressing is whether they should be represented by lawyers of IEBC.
I was dealing with the response that they have filed. And that is the point that I think my learned friend, Githu Muigai, was alluding to. Will that response still be on record, or are they limited to the affidavits that they had filed and which have been allowed? Because if the response is also part of the record, a response filed or a new petition filed outside time, I do not know whether I need to respond to it and whether it will be admitted by the court, notwithstanding the strictures in Article 140. I hope my...
We've got a new senior counsel. What we are dealing with is the application of whether we should allow council to represent the 4 commissioners. As you can see, the 2 factions are insisting they are representing IEBC.
And in the mix of it is that response that has been filed by Learned Counsel Paul Muite's team.
We,
But
we
maybe
will
if-
retire to consider that application,
Please,
which was, I think, filed out of time. So
yes, that
last
is
night.
filed out
So
of time.
we'll consider it and come back with a ruling.
Correct.
Yes.
That's number 1. Number 2, again, something which may be lost out. When I look around me, my colleagues each representing a party. And as you said, some could be secondary petitions. They each have, under the guideline you give, 4 lawyers each. Very carefully, I did. And
It's only the main parties who have 4 lawyers.
all the petitioners are main parties.
Okay.
All the petitioners are main parties. Say, for example, petition number 1, they have my learned friends, 4 of them. And the same goes for each petition. I don't know why the noise is being generated. I can see a battery of governor. Is each 2-2? Or, huh?
Mr. Ngatia, the other petitioners have 2, not 4.
Oh, very well.
So we really have no reason to complain.
Thank you so much, my lord. Nonetheless, actually, that makes my work much easier. Each has 2, they are 8, 16, or against nullification of 1 person. And then that 1 person, you limit him to 4 lawyers. I appreciate, I'll be the first one to say we are living in difficult times. But surely it will be very difficult for me, and I say this in all fairness, to be able to master a defense against all the 18 lawyers when all we have is a team of 4. Let me say the last thing, Madam Chief Justice, because your fairness is legendary. The total time given my learned friends, all the 8 of them, is 8 hours. I have been allowed 3 hours. I would have requested you, Madam CJ, if there's any way you could allow me at least half the time that my opponents have, so that I could at least be able to master a defense in relation to petition number 5, the primary, and the proxy ones, the 6 of them. That is all.
My lady, if I may. My lady, if I may have your indulgence for only 1 minute. I noticed that my lady observes that this application was filed out of time, and we admit that that is so. But the reason is that it is not one of the applications contemplated under the rules. Issa Mansour, Esquire, filed his papers on the 26th. We did not expect that there would be another petition filed in the guise of a response, because what the 4 commissioners have done is to file a fresh presidential petition outside the constitutional timelines. We agonized as to what we ought to do in the circumstances, and the only thing open to us was to make the application on the 29th. So we beseech you that if you find that it is out of the normal timeline, you nonetheless grant us an extension of time, because resolving this matter is very fundamental to resolving the petition. It is, my lady, this court that has repeatedly cautioned us that we should never attempt to resolve such a weighty matter as to who is the legitimate president of the Republic of Kenya on the basis of subterfuge. And I do pray, therefore, that you consider very seriously, Milady, that application so that you may guide us accordingly. As regards time, we have another request. We are facing 7 petitions, and all these people are attacking the integrity of our technology, the capacity of our personnel, and above all else, the integrity of our chairman. We would ask for just 1 more hour so that we can meet these 7 petitions that have been allocated 10 hours. Thank you very much, my lady.
My lady, the president of the court and members of the court, I think the court has been very fair, looking at the time allocation. We have 7 petitions, and in all those 7 petitions, we have been given a total of 6 hours, with a little bit more time for the petition number 5. We have 3 hours. The respondents similarly have 6 hours. And I think that taking into consideration the time that you have to hear and determine the petitions, I think that the time allocation has been very fair. Otherwise, if you have to follow the arguments by my learned friends for the IEBC, you would similarly say that our petitioners had a lot more to lose than the other petitioners, and therefore we should be given a little more time. But I think in the circumstances, I think the court has given a fair consideration as to the interests of all the parties and how to accommodate all the parties. 6 hours for the petitioners and 6 hours for the respondents. It's 6 hours. I think you do a little bit of mathematics, you'll find. Yeah. I did a little bit of mathematics. The other matter that I wish to draw the court's attention there are other pleadings that have been filed out of time without the leave of court. I would invite the court to look at those pleadings that have been filed out of court, out of time, and without the leave of court, to be struck out, because parties that have been served with these pleadings at the last hour would not be able to respond to them. And one particular affidavit which has been served, filed out of time, is the affidavit that on the face of it is by one Hilda Kavonga. That has been filed by the Electoral Commission, the first faction of the Electoral Commission. And at the last page, it says it's been sworn by Martin Wachira Nyaga. So some mutation, biological mutation must have taken place. And that, I don't know how to crack that one. But the bottom line is that they've been filed out of time and without leave of court.
Yes, Honorable Madam Chief Justice and the court, I have a small application that I thought I would bring to the court's attention. Due to late service of responses, the first respondent, the first petitioner in petition number E007 prepared responses and a further affidavit that were brought to the attention of the registry, but were rejected because of the question of time. In the same breath as my learned friend, Professor Gidu Muigai, who has not filed a response to an application by ISA, we would seek leave, Your Ladyship, to file the affidavit. It's a small further affidavit of only 44 paragraphs, which is as a result of late service, Your Ladyship, and submissions by the first petitioner in E007. Your Ladyship, in terms of representation, just weighing in on what my learned friend has submitted, Mr. Professor Gideon Mugai, Senior Counsel. There are only two professors and senior counsel in court, the two of us. Why can't all of them appear for the IBC? All the senior counsel can appear for IBC so that the court is richer with submissions from all parties, so that we hear the Chebukati faction and the Cherere faction, and I think the court then can make a good decision. Last, Your Ladyship, on the question of time, I just want to confirm that we only have 6 hours, like Senior Counsel Rengo said. And if my learned friend thinks that there are too many petitions, they can concede, that's all.
If may please, my lady, Honorable Chief Justice and my lords, on behalf of the petitioners in petition number 3, we were served in time by a set of documents from the IEBC. Then subsequently, last night, we were served with another set of documents from IEBC. Rule 11 of this court's rules are very clear on filing and service within 4 days. And we are greatly prejudiced if documents that were filed and served outside time does not allow us a rejoinder, and then those documents now constitute part of the record. We'll urge my ladies and my lords, that when you consider the issue of representation of IEBC, please take into account that in respect to petition number 3, the IEBC faction, minority faction, served us with their documents outside time, and we had no opportunity to file any rejoinder. So that whatever they filed, we cannot speak to it.
Can you name the party who filed late?
It was
And
filed by,
name the document which was filed late?
It was served on us late. We were served last night
Which
by the
document?
law firm of GA and Company Advocates. And we received the documents under protest and did indicate. Our prejudice is we cannot file any rejoinder to all the issues.
Please repeat the particular document which was filed late and by who? Which party?
My lady, I can speak to the service. We were served last night, last evening. They are the first and second respondents' documents filed by the law firm of G&A Advocates. The response to the petition from the same law firm. There is a replying affidavit by Michael Ouma, filed from the same law firm. The first respondent's replying affidavit, filed by the same law firm. All those, and there's several volumes of volume 1, volume 2, and volume 2 of their supporting documents was served on us yesterday in the evening. And under Rule 11, they were meant to file and serve within 4 days of filing the petition. We have a 1 day to respond. We cannot respond to all those documents that they filed. And we urge this court to be guided by the case of RAILA ODINGA 2013, that late service of the documents on us has prejudiced us, and the information therein should be expunged from the record. That's all, my lady.
Thank you.
Sorry, my lady, if with the indulgence, I can also enumerate the pleadings which have been filed out of time. The first one is an affidavit by Oduor Juma Joseph, filed in support of the first and second respondents. by G&A advocates. One, this was filed on Sunday, the 28th. This one is an affidavit of Catherine Wambui Kamau. And this one has been filed by, I believe, the same firm of advocates. This was filed on Sunday. The other one is an affidavit filed by the firm of Kithure Kindiki and Associates. This was filed today. And there's an affidavit, a further affidavit by Raymond Kiprotich Betts. The other one is an affidavit sworn by Martin Wachira Nyaga, an affidavit drawn by the firm of Iseme, Kamau, and Maema for the first and second respondents. This was filed on the 30th of August. This was filed today. Today at 2:45 a.m. The other one is an affidavit by Martin Wachira Nyaga, drawn by the same firm of advocates, Iseme, Kamau, and Maema for the first and second respondents. It was filed today, 30th of August, 2022 at 2:45 a.m. The other one is also an affidavit sworn by Hilda Kavonga, drawn by the first and second respondents, Iseme, Kamau, and Maema, filed on Sunday at 11 p.m. And the last one is an affidavit sworn by Martin Wachira Nyaga, drawn by the same firm of advocates, Iseme, Kamau, and Maema, on behalf of the first and second respondents. This was filed on the 28th of August, 2022. And as far as we're concerned, they're filed out of time and without the leave of the court.
Your Ladyship, we may actually go into a wrong series of saying what has been filed late and only taking certain documents and not all of them. As I was sitting here, I've been served with a petitioner's further affidavit filed today, filed yesterday, 29, And this is an affidavit that has been filed by the firm of Kenoti and Kibe Advocates. I think there's need now to take a stock of what has also been happening and which may not have been quite clear to the court. The e-filing system has had tremendous difficulties. And this you will confirm from the registrar, and I think all parties, where we tried to file, we had challenges, and that took a bit of time. But to me, because we all look first at our own self-interest, the beginning point is the response filed by the firm of ISA on 26th August, and which takes the form of a new petition. That would be the beginning point, because if you are to allow that, then that petition will stand unresponded to date, because I could not respond to a petition filed outside the 7 days. So as you consider all these rival arguments, allowing some and disallowing the others, I think the most fundamental would be the status of that response, which is in the nature of a new petition. Once that is resolved, the other petitions in my submission would be dealt with quite easily. That is all, Your Ladyship.
May it please you, my lady, the Supreme Court, my lords, my ladies, on behalf of the first and second respondents, that is the chairperson of the IB, Ngatia Senior Counsel, the IT infrastructure of the judiciary and the portal filed had a big problem on Saturday. We did an email to the judiciary, got a confirmation that indeed the system was slow. And so that is the first reason why a number of documents and finally, one John Wesonga. These affidavits were filed way after the petition had been filed. They raised new issues. Specifically, they raised issues touching on the IT infrastructure of the IEBC. The most responsible thing to do, my lady and my lord, was for us to then do the affidavits. In fact, before they came in to raise the concern, we had ourselves wanted to raise this as a preliminary issue with the court so that we get directions. Because after we responded to the issues that they raised in their own further affidavits without leave, they again yesterday filed further affidavits seeking to now respond to the affidavits that we had filed responding to the issues they raised out of time. What is most interesting is that even in the affidavits that they filed as late as yesterday, they still raised new issues seeking to expand the four corners of the petition that is currently before the court, which then has the effect of making that petition mutate in form and character. Now, that said, my ladies and my lords, from where we sit, because of the significance of the issue at hand, we had taken the pragmatic approach to say that even though they served us late yesterday, that is late last night, we worked into the wee hours this morning and did our draft responses to those issues, so that if the court be minded to consider those issues, because I think some of them are pertinent to be able to go to the root of what we are dealing with, then those affidavits could be put in place. We be allowed to file those, the ones that we had not served, responding to the areas that they raised in the affidavits yesterday. In the alternative, that then the affidavits that they filed yesterday should be struck off, so that then we are not prejudiced ourselves. But secondly, and perhaps more importantly, because there is now no clarity as to which affidavit was filed in time, perhaps the best approach